My name is Jessica. I'm with the St. Mary's County Library. Thank you for joining us tonight. We are very excited to have our guest panelists with us to go over estate planning. Please note this event is being recorded. We do have a Q&A option at the bottom of your screen. If you have any questions, feel free to type those in there, and all questions we're going to try and answer at the end. If you have any tech difficulties, you can message me directly or send me an email directly to that email address I sent you the link from. And I guess I'll hand it over to you guys now.
Thank you. Welcome, everyone. Thank you for joining us tonight. Our topic, of course, is estate planning. My name is Marsha Williams. Present with me tonight are Kathleen McClernan and Alicia Stack. We are partners at Williams, McClernan, and Stack. It's a law firm that is in Leonardtown, Maryland, and we are a general practice law firm. We have other attorneys, Tiffany Ashton, Joshua Brewster, and Gina Fioravante. And one of the practice areas we do handle is estate planning. So tonight, like I said, we will be discussing estate planning. This presentation should not be considered legal advice, so we have to give our warning, as lawyers typically do. What we are providing tonight for you is just a general overview of what we believe is necessary for estate planning and what documents we think that every person 18 and over should have. So, like I said, this is not legal advice. The content in this presentation was prepared by us, Williams, McClernan, and Stack. It was designed for general information purposes only. We advise that if you have any specific legal questions or you seek legal advice, to consult an attorney, and that way they can give you specific answers to your specific questions. This presentation does not establish an attorney-client relationship with you. So please do not share any confidential information with us. If you have general questions for us, please ask and hold those questions until the end, and we will make sure we will answer those questions for you. We believe it's important for all individuals and families of any kind to have their wishes laid out in writing, so it is clear to their loved ones and the state. We hope that the individuals talk about and discuss estate planning prior to any illness, or of course, we won't know when an accident occurs, but we generally suggest that people do this when they are well, starting at the age of 18. It's especially important for youth to have this information because once they turn 18, they are their legal healthcare decision makers. So as parents, I'm a parent of a teenager who's not quite 18 yet, but once he turns 18, he can say, I don't want my mama to know anything about me or my healthcare. But he might need me to make decisions regarding healthcare, his healthcare, if he is unable to do so. And also older adults, any age really, you never know when an accident might happen. So we are going to discuss the estate planning documents that you should have in your possession. Two of those documents are pre-death documents, and that's part of the estate planning overview, and one is after death, which is the will. I will be discussing advanced directives. Ms. Stack will be discussing financial power of attorney, and Ms. McClernan will be discussing will and what happens after someone dies. In regards to the advanced directive, also known as a living will, it must be in writing. The purpose of the advanced directive is to share how you want the end of your life to proceed. The advanced directive allows you to nominate a healthcare agent, and appoint a healthcare agent, which should be a trusted individual to make medical decisions regarding proposed treatments that extend life, like a breathing machine or a feeding tube, when you are unable to make those decisions for yourself. By having an advance directive and preparing an advance directive, you are able to decide now what type of life-sustaining treatment you would like in the event that due to an accident or illness, you can no longer make healthcare decisions that reflect your own values and priorities. In the advance directive, you will name a healthcare agent, and like I said, it should be someone that you trust and someone that you are willing and able to discuss your values with, and that you feel that that person will be able to make medical decisions for you in accordance with what you want. In the advance directive, you can also give direction for organ donation and funeral arrangements. A lot of time, people might put what they want to happen to them in a will regarding funeral arrangements and organ donations, but a lot of time, the will is not located until after a person dies. So it's important that you include this information and let people know this information, of course, before your death, and this can be done in an advance directive. The advance directive tells healthcare professionals if you want to be kept on life-sustaining procedures, have life-sustaining treatments, like I mentioned earlier, whether you want to have a feeding tube, whether you want to have a breathing machine or breathing assistance, and you can determine the stages where you want to have those things, whether you want to have those things or whether you do not want to have those things. For instance, if you are terminally ill and you just want to be kept comfortable, you can explain that in your advance directive. Furthermore, you can tell your healthcare advocate what decisions to make and how rigid to keep your wishes. So if you want your advance directive or the things in your advance directive to be followed to the letter, to the T, you can state that in your advance directive. Or if you want your agent whom you appoint in your advance directive to be able to take your values and your wishes that you've discussed in your advance directive and also consult with a healthcare provider to make a decision that they think would be what you want, you can explain that and state that in your advance directive. And the advance directive also allows you to choose donations, whether you want to donate organs, all your organs and tissues, or just specific organs to science, and you can describe your funeral request. As I stated earlier, when you are considering an advance directive and completing an advance directive, you need to pick a healthcare agent whom you can trust, whom you are able to speak with, someone who is knowledgeable about your wishes and values. You have to consider again how much power to give them, whether they have flexibility or whether you want them to follow the advance directive to a T. You will also need to consider who will be able to follow your wishes. So again, relating to a healthcare agent, will that person, when it comes time, be able to actually fulfill your wishes that you have stated? Or whether that person, you have to consider whether that person is going to be so upset that they won't be able to follow your wishes. So you have to really think about your healthcare agent. And you can also decide when it goes into effect, whether you want your advance directive to go into effect as soon as you sign it, or whether you want it to go into effect after a doctor certifies that you cannot make decisions for yourself. And this is a discussion that you can have with your healthcare agent, again, and knowing who your healthcare agent is, knowing that they won't take advantage of what you decide to do if you decide for your advance directive to go into effect immediately. And so that is a general overview of what an advance directive does. And we will move to the financial power of attorney, which is another pre-death document that we suggest people have.
Hello, Alicia Stack again. So financial powers of attorney. Again, it's a very important document to have in place as a part of your total estate planning. And what it does is it allows someone to make financial decisions, take financial actions on your behalf in the event that you're unable to do so. You can do it for a broad general purpose, giving them basically any authority to act as you under the law, or you can do it for a very limited purpose. An example of a limited purpose that you might choose to have a financial power of attorney would be you're closing on a house and you've got a long vacation planned, and it turns out the closing gets bumped to when you're going to be out of the country. Well, if you are comfortable doing so, you could give a friend or a family member power of attorney to sign those closing documents for you so that you could keep your trip. Then there may be other reasons where you would need to delegate a very specific action for a very short period of time so that someone could take action on your behalf when you could not. Most often, a power of attorney is put in place, again, as part of total estate planning to prepare for if there were an accident or you were to have surgery, something unexpected were to happen and your bills still need to be paid. Things may need to be done around your house. Money may need to be transferred to cover expenses. And this document would give the person you designate the authority to do those things for you, to make sure that the lights stay on, to make sure that your house stays paid for, to make sure that any doctors that need to be paid can be paid in the meantime. It keeps things running smoothly for you and for your family. And much like an advance directive, you can choose when it takes effect. Most often, when you're a bit younger, someone who's just turned 18 and probably all the way up through, 50s and probably even 60s, you may choose to have it only go into effect once you have been certified and competent to make your own decisions. And that way, the person you've named can't just, run off and empty your bank account without you. It would go into effect in that terrible event if something were to happen. But you can also choose, and like I said, generally people do this as they're getting older, but you can choose to do it at any age for it to go into effect immediately, which means that that person could take actions on your behalf at a time when you're also able to take your own actions. And that requires a very, very large amount of trust. Because what you're doing is you're handing someone a document that says they can go out, they can sell your house, they can empty your bank account, they have complete access to act as you under the law. And you can revoke that in writing, but it is a large amount of trust. And so again, it's a situation where you should think very, very carefully for who you name in that position, because it is a very large and weighty position to do that. Some other things that you can put in your power of attorney, you can name who you would want as a guardian of your person if you were to be incapacitated and that was needed through the courts. So you can specify your wishes in that respect. You can name who you would want to make a choice about an elective share. And I'm sure that'll come up as a part of the will discussion process. But if your spouse were to die, who would you want to evaluate the will and make sure that your rights were being protected under it? So like I said, it can be very broad in scope. It can contain a lot of powers. It can be limited, just 1 or 2 powers for a very specific situation. It can be go into effect immediately, or it can go into effect only after you've certified and competent. It can also be for a very short period of time. So for example, in that house closing situation, you might only give that person that power for a week or 2 weeks. Or it can be of an indefinite duration just until you revoke it in writing. So those are options you have to make it more broad or limited. There are certain statutory forms that are in the Maryland Code. That being said, as long as it is witnessed appropriately and it's notarized and it's in writing, technically anything can be done as long as it fits those parameters. I don't recommend just writing your own power of attorney, because even if you do appropriately witness it and you do appropriately notarize it, odds are if someone tries to take that to a bank, the bank is going to say, I don't recognize this, and they're not going to honor it, which doesn't really effectuate your wishes. We've had it as something as simple as how the notary stamp is. You can have an embossed notary stamp where you can kind of feel those bumps, or you can have just one that is an ink stamp. And we have had banks turn them away because they were an ink stamp instead of an embossed one, even though those are both valid under the law. So you should definitely have one that is drafted according to the statutory forms if you want a greater chance of it being honored the way that it should be honored, because they are bound to follow those statutory forms. And there are consequences for them if they do not recognize one that is drafted under the statute. Yes. So again, it's a hugely, hugely important choice who you give that power to, and when you choose to give them that power and how much. So that's, I think, all I have on powers of attorney. I'm going to go to Kat for wills.
Hi, I'm Kathleen McClernan. I am going to talk a little bit about wills. Most people know that that's the document that kind of states what happens when you die. And we think it's really important for anyone 18 and older to have one, because anyone 18 and older can, in fact, under the law, have one. Most 18-year-olds to probably somewhat 20s don't have necessarily a lot of money or property, but it's still good for them to be able to sit down and say, I've thought about what happens when I do die, and here's where I want things to go, because it does give that little special meaning to their properties and who they've thought about. As they start to get older, families who have children and minor children really need to start having a will almost immediately. It's important because you can appoint someone to be the trustee of a trust for your minor children, so all the money that goes into it to take care of them until they're older. And it's also because you have a guardianship, which you can have appointed for your minor children. So deciding who has the physical care of your children. The trustee has the financial care of your children. They may be the same person. They could be two different people, because sometimes you have people who are better with the emotional and physical caretaking than they are with the financial caretaking. Our one word of advice is please make sure they like each other. You do not want them to have 18 years of fighting until the children are old enough to go out on their own. Nobody wants that in the court system. Wills can also have specific requests. We see that a lot with family homes, family vacation homes, grandma's grand piano that gets passed down along a certain bloodline. Those are items that you want to leave to a specific person regardless of who dies in what order. Maybe even if your spouse is still alive, you still want grandma's piano because that's your maternal grandmother to go down to your children and skip your spouse. It also wills talk about who you want to be your personal representative and executor. A lot of people know the term executor, but in Maryland, we actually use the term personal representative. That is the person who will be responsible for filing your estate and taking care of making sure that the will is followed for your wishes. Again, it doesn't have to be a different person than the trustee or the guardian, but it can. We also recommend at least two options. Usually we have clients who leave their spouse as the alternative for the personal representative. And obviously you're with your spouse a lot. So if something happens to the two of you, then you want to be able to at least have another person in there to be nominated as your personal representative. You also want to make sure to talk about what are your goals with what you're leaving behind. Are there people that you want to ensure have access to money or items? Are there people you don't want to have access to money or items? There are specific rules in Maryland that talk about who gets what type of money from an estate. And if you don't specifically exclude them, they can in fact sue to end up getting some money, even if you didn't leave anything to them. So those are definitely things that you will need to have conversations with in the long run. You can also include where things spill over to the next generation. So say you decide to leave something for your children and before you pass, your child has passed, it can be sent to their grandchildren. So you don't actually have to amend the will at that point. But we do recommend that you at least have somebody take a look at your wills after every major life change. So after you have children, after you get married, especially after you get divorced, you're going to want to have that will updated. And not even just because you might want to take your ex-spouse out. If you want to leave your ex-spouse in, it's actually really important that you reaffirm by updating your will to say that you want that person there. Otherwise, some financial institutions will say they just never got around to it, but they're divorced and not leave it to them. And one of the things that you can do after you have your will drafted, a lot of people say, oh, well, I'm going to stick it in a Social Security or not Social Security, a safety deposit box. The problem with that is it's hard for people to get into, again, unless they have that power financial power of attorney and you're still alive. Otherwise, they've got to figure out where your key, how do I get into that safety deposit box? So we recommend especially if you're going to be living in the same place for a long time, or at least in the same state, is to file your will with the Register of Wills in your local county. In St. Mary's County, it's $5 to file your will. So it's a nominal fee. And that's also where you're going to end up having your personal representative start an estate once you do pass. They'll have to file the will at that Register of Wills. So it's much simpler just to have it there already. It kind of adds a little layer of security, especially if you happen to have one of those families who you think is going to fight over everything. It just kind of says, well, I did this when I was competent and it's there. So it's harder for people to say it was made up or not the newest will or things of that nature. If you do change your will, you can request the Register of Wills give you your old one back and refile the new one, again, for a simple $5. So I did want to touch briefly on estate administration, which kind of flows from that will. What happens when someone does die with a will? Well, again, the person who thinks they are the personal representative or someone close will need to go to the Register of Wills where the person had lived and open an estate. And there are two types of estate, small and regular. It depends on how much money or assets are in what will be the estate. And they fill out some paperwork to become the personal representative and have that will opened or send that will in to the Register of Wills. And then from there, you're able to administer the will. You're able to sell property if you need to, close out bank accounts, transfer titles. Like if a house is left to children, you can transfer that title into their name. And that's all done through the estate administration process. To talk more in depth about that would actually be a whole nother seminar on its own. So I just wanted to touch briefly about that just because one of the reasons, again, we think it's so important to go ahead and file your will with the Register of Wills is just because of that. If you believe that you're going to be moving anytime soon, feel free to take it with you. But if you end up moving and something does happen immediately, the person in the new state that you're in can reach out to the Register of Wills and obtain your will from there. As long as your will, in general, as long as your will is done by the rules of the state that you lived in when it was created, then it should be approved by the state that you move into. And as always, lawyers, we recommend getting a checkup of your financial documents, regardless when you move states, just to make sure it does in fact accommodate their rules as well. Just like you would with a doctor to check up your health as you move. Same with finding a new lawyer. And so that would be the end of the will discussion. So those are our three important estate planning documents that we think everybody should have, and we're happy to move on to questions and answers. But Jessica, if I could have you move to slide number 4, we can give you some, here are some websites for some good information. The People's Law Library of Maryland is a wonderful resource for people that need to kind of have a basic level of understanding of what's going on. And so we did list the general address along with the 3 different descriptions of the different documents we talked about. St. Mary's County Office of Register of Wills is located at that website. And of course, our website, in case you wanted to take a look at us and what we do.
Thank you, Ms. McClernan and Ms. Stack. I see that we do have a question. Some of the question has been answered, but I will read the whole question. Do these need to be filed, recorded someplace, or just kept in a safe place? Do they have to be done by a lawyer? Can we find a template of statutory forms? I have seen these documents in packages and staples. Does a person need to include court or lawyer when being a personal representative? And so, as Ms. McClernan mentioned regarding the will, we recommend not putting it in a safe deposit box, because a lot of times you need an estate to open the safe deposit box if you are not listed. So we recommend that you keep the will not only in a safe place in your house, but also with a register of wills in the county in which you live. In regards to the advance directive and power of attorney, yes, keep it in a safe place. Make sure people know where that safe place is, because it's important for people to know, because when these documents are needed, you're either unconscious, incapacitated, or at the end stage of your life. So people need to be aware of these documents beforehand, and people need to know where these documents could be found. Also, you can always give a copy of the advance directive to your primary care physician, or if you're going into surgery or having any medical treatment done. Sometimes the doctors, hospitals ask you if you do have an advance directive, and if so, provide a copy to them. Here in our office, it's our practice to not only have you keep the original, but to give you copies, or at least an additional copy, so that you can have a copy to give to your healthcare provider. And typically they just scan the advance directives and give the original back to you. So it is good to let your healthcare provider know if you do have an advance directive. In regards to the packages that can be found in Staples, we do not recommend using those packages because they might not be state specific. And typically they're just very general, and they don't take into account, like we said, state specific law, or take into account or go into depth what your wishes would be or could be, and what you would like to see happen. In regards to the advance directive, Maryland has an advance directive and it's listed online. But the other documents, yes, there is a statute for the power of attorney, but again, it's a statute and you probably wouldn't know where to look. But Ms. Stack and Ms. McClernan can speak more in regards to templates of statutory forms, and if they have any other suggestions, and about whether a person needs to include the court or a lawyer when being a personal representative.
So for the financial power of attorney, I think if you go to that power of attorney page on People's Law, you can link to the different statutory forms. So those are laid out in such a way that they can be filled in. It's not something that you can just, the advance directive, if you go to, I think it's the Attorney General's page, you can download their form and fill it out, and you just have to have it appropriately witnessed. The power of attorney isn't exactly like that, where you could just download it. But there are forms that are directly written into the statute. So could you copy and paste them? You could. It's one of those things, again, as Ms. Williams was saying, you can try to do some of these things on your own, but to ensure that they're done how they need to be done, it is better to seek legal advice to make sure that you're following the rules about, again, how they're signed and how they're witnessed. Because if they're not witnessed appropriately, if you don't have the correct number of witnesses, if the witnesses are not watching it in the way that they're supposed to watch it, it might not be valid. So the signing and witnessing portion is almost as important as what is written into them, because if they're not done appropriately, they can be challenged. And Ms. McClernan can talk about that when it comes to wills as well.
And again, I think the biggest issue, like Ms. Williams stated, is that the specificity not only to the state, but to the person. Anything that you're going to get in a package form from Staples or some other websites and things of that nature is just not tailored to your specific needs. And you may not have the knowledge of questions that you need to ask. And so having that discussion one-on-one with an attorney can help them figure out what exactly you need, what are you looking for, what are your concerns, and things that paper just unfortunately can't give you. As far as does a person need to include court or lawyer when being a personal representative? So technically an estate administration proceeding is in court. It's called orphans court. It's quite different than normal courts. It's nothing that anybody's probably ever seen normally from traffic court or criminal court or even family law court. Its sole purpose is basically to deal with estate administration. And you may never need to go in front of the orphans court. A lot of estates are done on an administrative basis, meaning you just turn in the paperwork to the register of wills and it gets signed off on. But if there is somebody who's contesting portions of the will, or it doesn't go through the approval process, sometimes you do in fact have to go to court with the orphans court. For a lawyer, you don't need to have a lawyer be a personal representative, but a lot of times we do, at least as a law firm, we either represent the personal representative or we represent the estate. And having that lawyer can just help you work through all of the documents. The Register of Wills website does have all of the forms that you can fill out, but some people just in their moment of need that little extra help, or want to turn it over so that somebody else who does it on a regular basis can help them with it, so they don't have to be in the process of grieving and also trying to follow the timelines, because it is kind of strict. They generally try and have estates closed within 6 months to a year. Bigger estates, things that have to be sold, obviously take a lot longer. So no, you can do it on your own. Again, it really just kind of depends on the breadth of the estate. It's also depending on where the person died. We do have a lot of people, because this is a big military town, where maybe a parent has died here, but they're in California. And so it's just easier for them to get a lawyer involved to be the personal representative or represent them here and deal with the property, so that they don't have to keep flying back and forth, especially with the pandemic. We've been doing that a lot, so that they can do as best they can from afar.
Thank you, Dee, for asking the question. We hope we answered it for you. I see another question in the chat from Eileen. She asked, can you talk about trust and the process of having a trust prepared? Can you have both a will and a trust? And what are the advantages or disadvantages of having one over the other? Should a person have a certain amount of assets be more inclined to have a trust prepared instead of a will, or both?
So I guess I'll start and then hand it over to Ms. Stack. For the will purposes, you still want to have a will, no matter whether you have a trust separate from a will, meaning that you've created a trust while you're alive and put property or money into it, or you're just talking about the trust that you've set up within your will to put money and assets in for children or minors. You still want that will, because that will still selects your personal representative and helps with the guardians or the trustees for those children, things that still need to happen. Even if you manage to dump almost all of your property and assets into a trust, there's still going to be things that will be needed to be taken care of by an estate process. So having that will, just choose that personal representative, is definitely a better person. And then I will turn it over to Ms. Stack.
So there are different kinds of trusts. So Ms. McClernan was talking about a trust that's created for your children. That's called a testamentary trust. It is created at the time of your passing, if the conditions that are in your will are fulfilled. So you may have a trust for your children in your will, but it's only if they're under the age of 18 or 25 at the time of your passing. If your children are in their 30s or 40s when you pass, that trust may never get created. But if they are minors, then it would become a trust document at the time of your passing. And the trustee would have to help that go into effect along with the personal representative. But there are other trusts that you can have written as a separate document while you're still alive. We're not going to get too in-depth into them right now, but there are various types of living trusts, so some that you can revoke, you can kind of uncreate, and some that you cannot revoke. And there are advantages and disadvantages of each kind. Most often, people put assets into a trust because they're trying to avoid estate taxes and transfers after their passing. They are a lot of times less common now than they were some years ago because the estate tax limits have been raised so significantly. I think the federal, gosh, I just looked at this last week. I mean, it's millions of dollars. So your average family is not trying to transfer millions of dollars at the time of their passing. So for most people, they are unduly burdensome. They don't provide a lot of benefit, but they create a whole lot of hassle to go through and transfer all of these assets, retitle homes, retitle cars to a trust. And Maryland's estate tax is relatively low compared to the federal estate tax. So again, it's something that if you did the math on how much it would cost you to do all those transfers and manage all of that, it probably would not be worth it for the average family. But in the event that you do have millions of dollars of assets that are going to pass, then you may want to consider whether or not you want to put your assets into a trust and the type of trust. And that is definitely a conversation that you should sit down and have with an attorney and probably also with your financial planner and have them looped in together, because in addition to talking about a probate process, you're also talking about tax consequences. So you're going to want to talk to people who have a lot of knowledge of both the advantages and disadvantages to your situation and the tax consequences for all of that, and kind of have a team that are really working together for that effect. So if you think that you have the amount of assets where a trust would be helpful, you should absolutely not get one from a form at Staples. You should definitely speak to a qualified attorney about that.
Thank you. I see another question, and it says, can you have more than one healthcare agent? Yes, you can have more than one healthcare agent. In fact, you can also name a backup healthcare agent if the one that you have as the priority or number one is unavailable. But in naming a healthcare agent, you should make sure, if you're going to name co-agents, you should make sure that they are able to communicate with one another, make joint decisions. Because like I said, when these forms are used, it's during a stressful time in people's lives. So you want to make sure that they have the ability to communicate and reach joint shared decisions, work well together, and listen, to a doctor. For my situation, even though a co-agent is not listed in our documents, we have a relative who is a doctor. So we've made a wish or a statement in the advance directive, in our advance directive, to consult with this relative. So not necessarily her acting as the agent, but she is a person that we trust, that we would consult with, in addition to the attendees, the doctors. But we have made it known that yes, before making a decision, we're giving you the leeway. I'm giving my spouse the leeway to consult with other people in order to make an informed decision that goes with what my values are and what my beliefs are. But there's nothing stopping you from having co-agents. And Ms. Stack, do you want to add anything regarding power of attorneys?
It's really the same information when it comes to the, financial agent. It's, if you're going to name two people as co-agents, you have to make sure that you truly believe they will make joint decisions, because it's going to be a lot of trouble if they can't. And just as Ms. Williams said, when these documents are being used, they are very, very stressful times. And yes, when someone is sick and dying, it brings out a lot of emotions in a family, and you can absolutely name two. I strongly recommend to most of my clients that they don't, advise them to consult with that other person, but I strongly recommend leaving the authority with just one person, and that way you avoid those conflicts if you can.
When it comes to wills, in general, we do see a lot of co-guardians because there's a lot of married people that we're leaving children to, like our sister and brother-in-law or our parents, so mom and dad. But then you also have to consider, and usually what I do recommend to my clients is, what happens if they get divorced? Is it still you want the children to go there, or do you actually want them to go someplace else? And so that's just something that you have to take into consideration. And it's not unusual for it not to go to the family member. Sometimes it's the in-law that you prefer. So, it goes different ways. But in general, again, with the trustee, so the financial person or the personal representative, in general, it is better just to go ahead and do a single, not just because of the reasons Ms. Williams and Ms. Stack described, but also because they have to sign off on everything. And if you are not local, it just delays everything and makes it so much harder. And especially for like estate administration, you have co-personal representatives, everybody has to get a bond. So you have to go through the insurance process. Everybody has to sign off on everything. And so it just gets complicated. The more people, the more cooks you have in a kitchen, right? It just gets a little more complicated. Unfortunately, we've seen things where a mom and dad want to leave a piece of something to every kid, but sometimes that means that we've ended up with houses with 9 people on it. And you can't get 2 people to make a decision, and getting 9 people to make a decision means you're in court and costing probably more than that piece of property was worth. And so sometimes you just have to think about that and hope that the person that you put in charge to make the decisions and to make things happen are going to do that and to take care of their siblings or children or nieces and nephews, and that we can hope that it will be peaceful in the end.
And I have to say, the property thing made me think of it. I know sometimes people think, well, I don't need something very specific. I don't have a lot of money. I don't have a lot of assets. But do you have things that are emotionally significant to your family? Because that can cause an argument as much or more than something that has monetary value. If you have grandma's jewelry, and maybe it's costume jewelry, but you remember her wearing that necklace or that brooch or whatever it is, every single Sunday to church. Maybe it's my own personal family. Maybe it's grandpa's workbench in the garage, and that workbench has no monetary value, but all the grandkids remember sitting up there next to him and working alongside of him. And those are the things that have so much value to people. And those are the things that they will fight about after your passing. So you're thinking, well, I have, $50 to split 4 ways. But if you have something that is meaningful to your children or your grandchildren, name it in your will, so that they know who it goes to, so that it's not something that they're fighting about later. Because everything you can do to be more specific, that is a conflict you're going to save your family when they're all hurting because they miss you.
And I see another question in our chat. How much of a bond do they need? Meaning, how much of a bond does a personal representative need, Ms. McClernan?
So that is based on the approximate value of the estate, of the assets. A nominal bond is $50,000. You're obviously not paying $50,000 to get bonded. It's the insurance company. It's based on your credit score, your work history, basically how insurable are you that you're not going to run away with the assets of the estate. But so the cheapest is a nominal bond, which is $50,000, and then it goes up from there depending on, again, the value of the estate.
And I don't see any more questions. I will give people some time to type another one. Here, one came through. Can you leave something to someone but limit what they can do with it, or set it to go to someone else after the death of the first person you left it to?
So usually only titled property. I have to think about this. This is a good question. We've done it. You can do it with houses, right? Especially with houses that you want to leave to family members. There are things called life estates where you can say that a person gets to live in this home, but they don't get to sell it. And so once they pass, it moves on to the children or grandchildren or whoever you put on the deed. I would imagine you could do the same for other titled property, but anything that then isn't titleable, which the state couldn't keep track of, I don't think that we could restrict how it's used or moved in the future. That's my best guess without having to take a moment to look it up.
Something I can think of as an example, if there's again, a piece of, grandma's jewelry and she leaves it to her daughter and her daughter dies before her, you can state specifically, if this person dies before me, it goes to someone else. So that's a little different bit of a situation, but so if that person predeceases you, you can state who you would want it to go to instead if you didn't want it to go to their heirs.
And again, thank you for the questions. They direct our attention to something specific, and get our brains working. But I don't see any other questions in the chat or the question and answer. So I want to thank everyone for attending the estate planning seminar. We strongly encourage everyone to consider estate planning and have the documents ready for when that time comes, especially we all know that we will die eventually, so it's especially important to have a will, but even the pre-death documents, because we do not know what the future holds. And it's always better to be prepared and not having to worry about family members, friends fighting over what should happen to you or what should be done on your behalf. So if you have any questions, you can always consult the People's Law Library of Maryland, which is a free resource, as Ms. McClernan stated. And you can also visit our website. But if you have specific questions, we also strongly suggest that you consult an attorney, because that attorney will be able to answer your specific questions and give legal advice relating to your specific needs, because this is a general overview. It's not meant for legal advice. It's just a general overview. So thank you, everyone, for coming to our presentation. Thank you to the St. Mary's County Library for hosting this event. And hopefully we will be able to do some more events like this in the future.